Hello and welcome to our seminar on OSHA and COVID. This is about workplace safety and responses to the current pandemic. My name is Steve Kohn. I'm the chairman of the board of directors of the National Whistleblower Center and a partner at the law firm of Kohn and Colapino. It is my absolute honor to introduce our main speaker, the person I'll be asking questions to, Professor Emily Spieler from Northeastern University. She is, in my view, and having worked in this area for many years, the expert on OSHA and workplace safety. She wrote an absolute brilliant article for the ABA Journal on whistleblowers and safety at work. It's mandatory reading. It lays it all out. She's the former dean of the Northeastern University School of Law. She served in that position for about 10 years, and she's currently a professor of law. For a number of years, she was appointed by the Secretary of Labor in the Obama administration as the chair of their Whistleblower Protection and Advisory Committee. And in that position, she really got a feel for what was happening in the Department of Labor and OSHA. I think making her the most important spokesperson on issues with OSHA and workplace safety. And before I start my questions, I just want to say why this particular seminar is so important. Because OSHA is supposed to guarantee a safe working place for every American. And for there to be a return to work, you need safety in the workplace. And it's the OSHA law that stands as the predicate for that. And so it's with incredible honor for here in this Whistleblower Week that Professor Spieler has agreed to answer some of our questions. Welcome, Professor.
Thank you, Steve.
So just going to start it out. Given the current situation involving the pandemic, are workers currently facing retaliation for raising safety concerns about COVID-19?
Absolutely. So let me just back up 1 minute. One of the problems with what's going on with OSHA and the pandemic is that most people feel that essentially OSHA is has completely abandoned its responsibility to provide a safe workplace. So the guidelines are not requirements. They they do not have any specific rules that cover this kind of risk, which means that they would have to look at enforcement under the general duty clause of OSHA. They put out a guidance that explicitly said, we're basically not going to do anything in workplaces that aren't at the highest risk, which included healthcare, of course. But they haven't gone out and done very many inspections. And as far as we've been able to tell, at least federal OSHA has only issued, at the last time I read about it, 1 citation nationally on COVID response. And at the same time, we're hearing, of course, about spread of disease, not only in for healthcare and first responders, but in warehouses and restaurants and meatpacking plants. And so workers have been coming forward to raise serious concerns about the extent to which they are being protected. And this has been, at least up until the recent reopening, mostly essential workers who've been, by and large, expected to come to work, irrespective of how prevalent the pandemic was in their area. And so what we've seen is an incredible outbreak of COVID, for example, in meatpacking plants where people work very closely together, and they are unable to distance themselves and often are not given personal protective equipment. So in response to this, workers, and there have been anecdotes about this in almost every newspaper around the country, workers have come forward to raise their concerns. And I was going to say, not surprisingly, although sadly, what we're seeing is a surge in complaints about retaliation. So OSHA, federal OSHA itself has received about 3,000 complaints as of today, specifically related to retaliation in raising COVID concerns, a lot around personal protective equipment, but also around other issues that employees think employers should be using to address the pandemic. And that exceeds the total number of complaints that federal OSHA received in fiscal year 2019 for all types of hazards. And that doesn't count the 21 states that have state OSHA plans, which we're going to end up talking about in a minute, because those state OSHA plans actually have some different provisions for on retaliation. But we don't really know at this point how many complaints have been received in state offices. 21 states enforce the health and safety provisions as state provisions, and federal OSHA doesn't come into those states other than to act as a kind of background oversight. So, for example, in California, which is a state OSHA planned state, we've heard that there have been numerous complaints about retaliation. So it's a big issue for sure.
So just a question. You mentioned earlier that there's been one filing, and in terms of supporting an employee.
No. This is what I was referring to was the health and safety protection side of OSHA, not the whistleblower side. So when they do an inspection, which they haven't much been doing for COVID, but they have done some. And when they do an inspection, they go back to their offices and they have to decide whether they're going to issue a citation against a company for their failure to provide a health and safety workplace. And they have up to 6 months to issue the citation. And during the pendency of the citation and the litigation of it, the employer doesn't have any obligation to correct the hazard, which just parenthetically is not true under the Mine Safety and Health Act. And so because there's no specific regulation on COVID or aerosol-borne disease for OSHA, they have to do it under the general duty clause, which is actually complex, and general duty citations have to go through multiple layers of review before they're actually issued. So it's just a complete disaster, frankly, in terms of the presence of a federal agency that's supposed to guarantee health and safety to workers. They are just absent. And so workers are coming forward more and more to raise concerns about what's going on in a whole variety of ways. And not surprisingly, in my opinion, as I said before, because of the nature of employment regulation in the United States more generally, a lot of these workers are facing retaliation.
So a question then is, does OSHA currently provide protection to the whistleblowers, to workers who are stepping forward and raising complaints? Is it working for those employees?
It's a little hard to tell, frankly, because the data isn't reported out as to what exactly is happening to those investigations. They're putting up on their website, here are the number of cases we've docketed, and here's what we're doing for investigation, and here are the number we've closed, but they're not telling you anything about what the workers might be getting. And part of the problem is that the provision, the anti-retaliation provision in federal law is, in my opinion, incredibly weak, and certainly the weakest of any of the federal whistleblower laws. It was among the first, 1970. It's never been amended or strengthened, despite the fact that we know very well that it's incredibly weak. So a worker files with there's a variety of ways that a worker can file, and some of that was actually made easier during the Obama administration. There's a complaint form online, or you can call or write to the local OSHA office. And if the investigator who's assigned thinks that the claim raises an issue under the section of the law, section 11C, then they'll docket it and investigate it. But here's the problem. There's absolutely no way for that worker to take that case forward on their own beyond the investigation. So here's what happens. There's an investigation done, and if the agency says, no, we don't really think this case has merit, the worker can, and if the worker has representation but often these people are pro se without legal representation. But if the worker can appeal to the central office in Washington, D.C. for a review of the file, but it's an informal review. It's not an appeal really on the merits. Did the investigator do a good enough job? That's it. Sometimes they will send them back for further investigation. So what happens if the investigator thinks it's a good case? Well, they try to settle the case. And in what I found in my research, not related specifically to COVID, is that on average, these cases were yielding about $7,000 in back pay and damages for the workers. So this is not a pot of gold at the end of the tunnel by any means. And part of the problem is that if the investigator thinks that the case has merit and thinks that the employer is not willing to settle it adequately, then the only thing that can happen is that the investigator can then recommend to the solicitor's office of the Department of Labor that the solicitor file a case in federal court on behalf of the worker. Incredibly few cases are filed. And as a result, there's amazingly little back pressure into the settlement process to suggest that the employer better settle for a decent amount because otherwise there's going to be further litigation. Most of the whistleblower laws that OSHA investigates have both a right to go to a full administrative hearing that's de novo and with a full evidentiary hearing, or they have a kick-out provision to take, and so that a good case with a lawyer can be taken out into court. OSHA has neither of these things. And so the result is that the OSHA 11C provisions are just phenomenally weak. And although there are some very good investigators in the OSHA system, some maybe not as good, but there are some really terrific people who really care, but there's a limit to how much they can get for a complainant in these kinds of situations.
So what you're saying is that if an employer refuses to negotiate, they have an unsafe working condition, and they say, you know, we don't care, make the workers work in these terrible conditions, unless the Secretary of Labor files a lawsuit in federal court against them, that employee has no rights, and that employee cannot on their own file a lawsuit against the employer using OSHA, the OSHA law. Is that the situation?
Yeah, so there are a couple of ways, a couple of exceptions to what you said. One is that in the state plan states, there are about, I think, half a dozen states that give a private right of action to the employee, and they can bring their own litigation, either waiting for a while for the investigation or some other provision, but there is allowance for that. And so it's not universal around the country, but it is true in federal OSHA states. And then there are some ways to, yeah, go ahead, I'm sorry.
Oh yeah, the follow-up to that is, what would be the alternative if federal OSHA doesn't let the employee protect their own rights in court? Okay, you said that some states, I guess 6 was the number, that will let you do that.
6.
What other alternatives are there for an employee who's being forced to work in unsafe conditions to protect themselves?
So there's a lot about this right now on the various lists that I'm on, because the people who are interested in protecting workers, both from retaliation and from hazardous conditions, understand that an OSHA complaint may not get you anywhere. Now, occasionally with the right representation at the investigatory level, and we've had this success in the Boston area, that people get reinstated with back pay and with addressing the health and safety concerns. But I don't know how often that happens. It's impossible to know. So alternatives are. So people are talking a lot about, and this is a kind of difference from, I think, what a lot of what's going to be talked about during this conference. People are talking a lot about collective action and the ability of workers to get together and raise concerns together. That has two components when you think about it as in terms of advantage. One is that if workers act collectively, they will be covered under the National Labor Relations Act, and these are pretty straightforward collective action cases. Whether or not people are unionized, they have that right. But also, I think sometimes there's been real success in that collective action in drawing public attention and media attention to the problems so that people are, employers are shamed into doing more. So that's one avenue. A second avenue is that in quite a few states, as you know, Steve, there's a common law tort if someone's discharged on retaliatory discharge. And in a number of states, I think it's about a dozen, I could probably rattle off some of them. And frankly, there's some overlap with those state OSHA states, but the courts have explicitly held that the right to complain about safety is a public policy, and that therefore there's the right to bring a common law retaliatory discharge claim. Now many of these people haven't been fired outright, so and most retaliatory discharge claims are limited to discharge. So, but that is a second potential avenue for litigation, and one that I think would be quite fruitful in more than those dozen states, because in most of the other states, they have a public policy retaliatory discharge theory that's been allowed, and the safety issues haven't really been raised. And this might be the perfect time to expand those rights in terms of people being deeply aware that this is a problem. The third thing is, is that to the extent that people are unionized, and that's a tiny percentage now of the private sector workforce, but to the extent that people are unionized, then their collective bargaining agreements basically always guarantee have a provision that guarantees just cause for dismissal, and they are interpreted so that the employer has to prove that just cause existed for discipline or dismissal. And so I always tell unionized workers that they should file a grievance immediately on their on any discipline or discharge that they think was not for just cause, and certainly that includes safety. And often unionized workers in more dangerous industries also have safety committees that they can go to who can help them raise these kinds of concerns so that their individual vulnerability isn't so great. But in non-union places, if you think about somewhere, for example, like Tyson Foods and the poultry industry, where, by the way, the Department of Agriculture has decided to allow speed up of the meat packing lines during this period when they are not able to have sufficient distance between workers. And so now, and there have been huge health and safety problems historically in those plants, and COVID is merely adding to those. And so we don't have an administration that clearly cares about the health and safety of workers. And if you have an unorganized plant in the South that's doing poultry work, and people have remarkably little protection, I think, from any of these laws. And possibly the best is the National Labor Relations Act. And I hesitate to say that because I've never thought of it as being very strong. You're muted. Steve, you're muted.
Brilliant, thank you. So what would be your advice to an employee in a non-union workplace that's confronting life-threatening, hazardous work where they may catch the COVID, bring it home to their families, get sick themselves? What's your advice to them given the issues with OSHA or the alternatives?
So you say life-threatening, but I think, and partly my partner is a occupational health physician and epidemiologist, so this is a big conversation in our household. What is the level of risk in these different places? And it really varies, and people's fears don't always match the actual level of risk. But if you take somewhere like the where there's been real endemic problems, like in meatpacking, and of course in healthcare, and in healthcare, a lot of it has to do with the availability of adequate personal protective equipment, because obviously these workers are going to continue to be exposed to people with COVID. And so maybe that's a little bit different from the people who are going into meatpacking or warehousing jobs and confronting a lot of problems. So what do you do if it's truly life-threatening? I mean, I talk to my students a lot about this, as well as to workers groups. Obviously, if you think it's life-threatening, you need to decide that it's not, that the risk of losing your job is not as bad as the risk of death or disease. And then you have to figure out what to do. And there is a provision in OSHA, in the 11C provisions, that says that you have a right to refuse dangerous work that's going to result in serious bodily harm or death, and you did so in good faith, and it was a reasonable, reasonable people would agree. But again, you're caught in the 11C process. I always advise people to file an 11C complaint. Not because it necessarily is going to work, but it's there and you can do it. And it does alert everyone to the fact that you feel that you've faced illegal retaliation. But I also think this advice that's traveling around the internet now about organizing around these issues and raising them collectively to your employer and to the media, and then if there's retaliation, going to the National Labor Relations Board regional office, may be the best that people have. The other thing that thing that some people are doing, which I think is really interesting, but doesn't really address this imminent sort of, I have to make a decision this moment about my job, is that there's really been an explosion of talking about how to litigate about health and safety in the workplace outside of OSHA. And there have been a number of lawsuits filed around the country, many of them on a public nuisance theory, seeking injunctions against employers for health and safety hazards. I don't think any of them have yet encompassed a so these public nuisance lawsuits have been filed against McDonald's, against Amazon Warehouse. The one against Smithfield in Missouri was dismissed, but it's a good theory for the meatpacking industry. And in those, they're asking for the employer to change its behavior, and the courts are issuing the injunctions and have been extended on a temporary basis and then extending them in some cases. So the ability to sort of, I mean, part of what's going on is that when you have retaliation for a safety issue, it's usually because someone is really concerned about what's going on the safety side. And the Whistleblower Advisory Committee was insistent, and I don't think this was when we first went in, which was way at the beginning of the Obama administration. We were just coming off the Bush administration, which had not been enforcing 11C. There had been any cases filed by the solicitor in federal court for a long time, and so there was nothing going on. And we told David Michaels, who was the head of OSHA, that one of the things he needed to do was make sure if somebody filed a retaliation complaint about a safety issue, that the people who did the inspections on the safety concern were alerted and went out and made sure that the safety issue that the person was raising was addressed. So it needs a two-prong approach, because what the worker wants is not to be retaliated against, but also to have a health and safety working environment.
Well, I just want to thank you so much. I know we could go on, and it's an OSHA. We could have many hours, and there's a lot to say, but our time is up. And thank you so much. This is going to be very helpful.
It was a pleasure, Steve.
Whistleblowers who sign in. Thank you so much. You take care.
You too.
Bye.
And be safe.
Thank you.